Hello and good day. My name is NORMAIMUNAH ABDUL AZIZ with metric ID 074537 and today I will be your partner 3 of the partnership business. So my position is actually on human capital advisor, or I could also do data and research analyst. So I'm a problem solver for this partnership business with a purpose to provide sustainable solutions to social problems through a mixture of research and collaboration to elevate societal well-being. So today I'll be explaining one of the clauses in our partnership agreement, which is section 5, in which it talks about the allocation of our profit and loss sharing between partners. So it stipulated, or I stated, partner 1 will be receiving 35% of the profit and losses, following by partner 2 will be receiving 30% of it, and partner 3, which is me, I will receive 15%, and partner 4 will receive 20% of the profit and loss of this partnership. So I will be focusing on 5.3, in which it talk about the amendment of loss and sharing percentage, in which the partner need to have a written consent but from all the partners if they intend to change or to amend the profit and loss percentage. So if they fail to have the written consent being signed by all the partners or been agreed by all the partners, then the amendment or the changes is illegal or unenforceable by the law, as this is by virtue of Section 26 of the Partnership Act 1961. So this shows that this clause is binded by the Section 26 of Partnership Act, in which it had to fulfill the right or protect the right of all of the partners in the business. Referring on to Section 5 of this partnership agreement, this section ensures transparency and fairness in how the partnership's financial success and its benefits or losses on its business are shared among the partners. The ability to amend profit sharing ratios allows for adaptability to changing business conditions and ensures that the partnership remains equitable for all partners over time. Overall, this section is drafted with careful consideration of the Partnership Act 1961, ensuring that this agreement is legally enforceable and could protect the interests of all partners.
I'm SUBRAMANIAM. Today I'll be discussing about the Section 13 of our partnership agreement, which focuses on dissolution. This section outlines the circumstances under which the partnership may be dissolved, the process for liquidation, and the responsibilities of the partners post-dissolution. So let's dive into the details. First aspect is the events leading to dissolution. The agreement specifies 5 key events that can lead to the dissolution of the partnership. So the first event will be the unanimous consent of all partners, where everyone agrees to terminate the partnership voluntarily. Next will be the bankruptcy, death, or permanent incapacity of a partner, which could disrupt the partnership's ability to operate. Third event would be the expiration of the partnership term if the partnership was established for a fixed duration. Next, a court decision, especially if the continuation of the partnership becomes unlawful. And lastly, any other specific triggers mutually agreed upon and stated in the liquidation process is carefully outlined to ensure fairness and compliance. Upon dissolution, a liquidator, either appointed by the partners or the court, oversees the process. The partnership assets will be inventoried, appraised, and sold to generate funds. Second, all outstanding liabilities, including debts, taxes, and obligations, will be settled in full. And the third one will be the final one, which will be any remaining funds or assets will be distributed among the partners based on the profit sharing ratios outlined in the agreement. The last part will be the post-dissolution obligations. After the decision is made to be dissolved, all relevant parties, such as the creditors, clients, and government authorities, must be notified. This ensures transparency and facilitates the settlement of outstanding liabilities. Additionally, it is important to note that the partners remain liable for any obligations incurred prior to dissolution unless explicitly released by other partners or creditors. To conclude, Section 13 provides a clear and structured framework for the dissolution of the partnership. It ensures that the assets are liquidated and distributed fairly among the partners while complying with legal requirements. By addressing these key aspects, the agreement prevents disputes and facilitates a smooth transition that should the partnership come to an end. So thank you.
Hello, my name is Puteriku Dzadini NORMAIMUNAH BINTI SAMSUDIN alias KUDDIK, and my metric number is 074550. Here I am going to talk about the dispute resolution mechanism. In case any of dispute arises from the partnership agreement, the partners will follow a certain structure approaches in a way to resolve the problems, which included 3 types of structure approaches, which is the first one is negotiation. In the negotiation process, where the partners that involved in the disputes may resolve the issues through the good faith of negotiation within the 30 days of the disputes arising. If the first step doesn't work, then they will move to the mediation process, where under the rules of the Malaysian Mediation Center in Kuala Lumpur, where the costs will be shared equally unless agreed otherwise. However, if the mediation fails, then the dispute will go to arbitration, where following the Asian International Arbitration Center AIAC rules that will be held in Kuala Lumpur in English, and the final decision will be final and binding. However, if the disputes doesn't resolve yet, then the matter will be brought before the courts of Malaysia and will have an exclusive jurisdiction.
Hi, I am Muhammad Hadi IZZUDYN bin IKMAL HISAM, and I will be sharing our group's reflection on the process of drafting our partnership agreement for Evergreen Consultancy and Research. This task provided us with a unique opportunity to collaborate as a team, enhance our understanding of partnership law, and develop our legal drafting skill. The first thing I want to talk about is challenges faced. One of the main challenges we encountered was achieving consensus on the profit sharing ratios. Each partner had different perspectives based on their financial contribution and non-financial skills. This required extensive discussion and compromises to reach an agreement that was fair and aligned with the principle of partnership law. Another challenge was understanding and applying the provision of the Malaysian Partnership Act 1961. While the Act provided a framework, interpreting it in the context of our agreement required careful reading and at times seeking clarification from external. The second thing I want to talk about is lesson learned. Through this process, we learned the importance of effective communication and collaboration. Each partner contributed unique insight and expertise, which enriched the final agreement. We also gained a deeper appreciation for the complexity of legal drafting and the need for precision in language to avoid ambiguities or disputes in the future. Additionally, this task highlighted the significance of the Partnership Act as a safety net, particularly for provision we had not explicitly addressed, such as default rules for profit sharing and partner withdrawals. Lastly, suggestion for future improvement. If we were to draft a similar agreement in the future, we would allocate more time to research the initial discussion to streamline the drafting process. Using templates or sample agreements could also serve as helpful starting points to ensure completeness and accuracy. Furthermore, setting clearer deadlines for individuals' contribution would enhance efficiency and prevent last-minute. As a conclusion, this experience not only improved our legal skills but also reinforced the value of teamwork and mutual respect in achieving common goals. We were confident that the skill and insight gained through this project will benefit us in our future legal careers.